Hello, happy Tuesday, and welcome to everyone. Thank you for joining us for today's webinar on AI patenting myths. I'm Jennifer Jannuska, Director of Data and Intellectual Property for Protein Industries Canada. I'd like to begin today with a land acknowledgement. I acknowledge that the head office of Protein Industries Canada in Regina, Saskatchewan is on Treaty 4 territory, the original lands of the Cree, Ojibwe, Saulteaux, Dakota, Nakota, and Lakota, and the homeland of the Métis Nation. We respect and affirm the inherent and treaty rights of all Indigenous peoples across this land and will honor the commitments to self-determination and sovereignty made to Indigenous nations and peoples. I'm going to turn it over briefly to my co-host, Jen Mielguy, for a few words of welcome and an introduction to the digital supercluster.
Awesome. Thank you so much, Jennifer. Bonjour, everyone. I'm Jen from the Digital Supercluster, and myself, as well as our office, are based in Vancouver on the unceded traditional and ancestral territory of the Musqueam, Squamish, and Tsleil-Waututh peoples. It's wonderful to have attendees from coast to coast joining us, and thrilled to be joining you all today. And huge thank you to Jennifer and our friends at PIC for putting on this session. Canada ranks 10 of 16 on the global OECD Innovation Scorecard. Whilst having come up from 12th spot in recent years, Canada remains below average, exhibiting relatively weak innovation performance. And this ranking change comes largely due to underperformance by Japan and Australia. Approximately 50% of Canadian ventures close within 5 years, and roughly 85% of Canadian tech firms have less than 10 employees. In order to address cross-industry challenges whilst creating technology products that can scale across industries and ultimately across the world, collaborative innovation and the development, ownership, and retention of Canadian IP is very much entwined into our innovation future and economic prosperity. Before we get started with the fireside chat, I just wanted to share a brief snapshot of the digital supercluster. We've 88 projects across technology leadership, COVID-19, and talent and capacity building programs. A total of $348 million has been invested, $191 million attracted from industry consortia, and 70% of co-investment goes to SMEs. Consortia are currently in development on over 150 products and services, and 45% are currently exploring international commercialization opportunities. As of September, over 50% of the 700 plus anticipated IP assets have already been generated across projects, all Canadian owned and nearly 80% generated by SMEs. There have also been 47 patent applications submitted by our members. We've over 1,100 members and 400 plus organizations across the country participating in projects, including ones which straddle our two superclusters in accelerating the innovation ecosystem model in Canada. Jennifer, I pass it back to you.
Thanks, Jen. And a few words about Protein Industries Canada. As a federally funded innovation supercluster, we're focused on supporting the development of Canada's plant-based food, feed, and ingredient sector. We're nearing the end of our initial 5-year program through 53 technology and capacity building projects over that time. A few highlights: over 600 new products and services have been developed. Over $500 million in project value has been injected into the Canadian economy. Over 300 new unique IP assets have been generated. And our projects have resulted to date in over 10,000 new direct and indirect jobs. AI is used in our sector for food formulation and recipe development, as well as for food safety analysis and quality assurance. In addition, there are other uses in agriculture, which we all know has become increasingly digital. At this time, I would like to invite you to get more information about the both the digital and Protein Industries superclusters. We'll be posting links for information and membership information in the chat. And I would also be remiss not to point out that PIC currently has an open call for expressions of interest in our new $30 million AI in agri-food stream. And we will put the link for our AI program guide in the chat as well. We are accepting submissions for that AI program until November 9th. So please do reach out if you'd like more information about that. So moving on to today's session. Today we are going to be tackling some myths related to patenting in AI. Today's format is going to be conversational, so please do feel free to put questions in the Q&A. You have all been muted, but we look forward to having you as part of our chat today. If we don't get to your question during the chat, we will try to tackle it at the end, or we will also make our speaker's email address available so you can reach out directly to him. And I'm going to crawl out of my shrubbery now to introduce our speaker and expert, Mr. Roch Ripley. Roch is a partner at Gowling WLG and the head of the Vancouver office's intellectual property group, where he focuses on IP strategy, patent drafting and prosecution, and technology commercialization across multiple technology-related sectors, including artificial intelligence. Now, Roch, you told me a funny story the other day about how someone had asked you a few years ago about the prospects for AI companies in Vancouver and how AI was doing in Vancouver. And I think you said that that you didn't see much activity going on, and you thought it was maybe a flash in the pan. Did I have that right?
I guess sort of. It was several years ago when we were talking about the different industry sectors that were coming up in Vancouver, and AI was accelerating in development, but there wasn't a lot of press centered on that in Vancouver. There's a lot of attention focused on it in Montreal and Toronto. And asking around the industry, a lot of people, frankly, myself included, thought there wasn't too much AI R&D or commercialization going on in Vancouver. And fast forward probably 5+ years, and I would say there's a lot. In fact, you know, I think I also mentioned that conversation right now. It's the bulk of what I'm doing. So yeah, I was wrong about that, and I was glad to be proven wrong. It's a transformational technology, and the more we can develop and harness it, I mean, from my perspective, the better.
That's great, and we're delighted to have you with us today. You mentioned that AI is the bulk of your practice now. What kinds of things are you seeing? What kinds of stuff are people working on?
Most of the stuff I see people working on is not so much. Some of it is actually development of the core AI models, like pushing that technology forward. I would say most of it, though, is application of AI models that have been created and published to particular technology sectors and particular problems. So, for example, you know, you may be in the video software industry, and you are customizing convolutional neural networks for purposes of image classification. You may be an insurance company, and you've got piles and piles of data, and you're now looking at applying AI models, and you've hired data scientists to parse through all of that. So I would say the bulk of what I see is application and customization of AI models to technology sectors.
Thanks. And one of the myths that I remember hearing quite a lot in my past career in private practice, and still probably today, and you probably hear this a lot, but people have a prevailing belief that you can't patent any kind of software, AI or otherwise. What do you say to that?
I say that's incorrect. There, the patentability criteria are novelty. That is, whatever you've created has to be different in some way from everything that's come before you. It has to be inventive. So even if you've got something that's different, is the difference between what you've got and everything that's come before you, is that difference big enough to justify being granted a patent? It has to be, I think what most people talk about when they talk about software being not patentable is the criteria we call subject matter. So in addition to, do you have a novel and inventive product or invention, subject matter says, even if you've got all that stuff, is it the right kind of subject matter or stuff in which you can be granted a patent? So, the classic example is if you're a mathematician or a physicist and you've developed new equations describing how some kind of scientific phenomena works, you can't patent that theory. If Newton's laws are super useful and they're applied in all kinds of inventions that are patentable, but you can't get a patent for, F equals ma per se. And that does rear its head in software. There are examiners and courts that say, you have to be careful when you try to patent software, because if you just try to patent sort of software in the abstract, then that runs afoul of the rule that you can't patent a theorem or a very sort of ephemeral idea. So in respect of subject matter, what you have to do for software, which includes AI, is generally describe in particular how you've integrated it into a practical application, or how it results in some kind of technical improvement to a computer. So when you've got that kind of practical integration, that's super important for software, and that's an important hook in which that you can rely on to get the patent. And then the last criteria for patentability is utility, which just means that whatever your invention is, it has to work. Doesn't mean it has to be commercially valuable. And with utility, traditionally, it's not really been a big problem in the physical sciences space. It's a big problem in the life sciences space. For example, if you're developing a new drug, until you test it, you really don't know if it's going to work. And the patent system says you can't just patent every single compound you've discovered saying maybe it'll be a drug one day. But in the physical sciences, historically, that's not been an issue. If I create, a new pen, blurred background pen, then I know full well whether it's going to work or not. I can touch it, I can feel it, I know, how these physical materials work. With AI, I think it's interesting because the nature of these AI models is when you've got a model and you've got a whole bunch of training data and you're going to throw this data at the model and see whether it actually improves the functioning of the model. I don't think you know really how that model is going to react until you actually test it. So in respect of AI software, I do think one thing that's different from traditional software patenting or traditional patenting of non-life sciences inventions is you want to include some of those simulation results or test results showing that, your theory was correct. When you threw this new kind of data at your AI model, it actually improved the functioning of that trained model relative to what came before it. So it's a very long answer of saying, yes, you can patent software inventions. You just have to be a little careful about how you go about it.
Now, in terms of whether something is abstract or whether it has a practical application or technology integration, is that something that companies need to figure out for themselves, or can they come and talk to you and you can help them through that?
Yeah, I think they should talk to somebody because I think quite understandably, anybody who is working on this stuff in industry, it's not an abstract problem to them, right? I mean, they have a real business. They're investing real resources into it, and they have a goal for where they want the project to go. And one of the things that makes this area tricky is that a patent examiner or a court might not see it the same way. So we do have those conversations with inventors where we say, you know, there's certainly a commercial application in your business. How do we phrase it or describe it in a way that is going to convince a patent examiner or a judge that this is not an abstract idea? Let's talk about how it actually improves processing speed. Let's talk about how you've integrated it into a workflow, and let's really emphasize that in a way that maybe wouldn't be intuitive to someone doing the actual R&D in industry.
Now, what if one of the things that you're doing with your successful AI model is driving some kind of a process, such as a manufacturing process after that, or making decisions in an industrial or manufacturing context after that? Would that constitute some kind of a practical application?
Yeah, I think it could. You know, manufacturing in particular results in some kind of tangible output. So if you've got an AI model that, for example, you've customized to work on an assembly line that does, you know, picking of certain goods off belts and positioning them in the proper bins and what have you, I think certainly that could be a practical application that that satisfies the criteria we've been talking about.
I want to switch gears here, but still talking about patentable subject matter. One of the other things that we do here is related to recipes. Many people believe that you can't, or perhaps you shouldn't, patent a recipe, that it's better kept as a trade secret. What do you think on that?
So yeah, I think you asked two questions, or you made 2 points: can't and shouldn't. So can you patent a recipe? Sure. The same criteria that I just described in respect of software or other inventions also applies to recipes. Is it new? Is it inventive? Does it work? That is, does what you say you create after you actually perform the recipe, does it actually get created? And is it eligible subject matter? And for something like a recipe, I don't think that'd be an issue because you're actually making something physical and tangible. So if you satisfy those criteria, can you patent it? I think the answer is yes. Should you? And I think the answer is it depends. If you've got a recipe that results in a product that you're going to sell and commercialize, and when it's out there on the market, someone could buy it and reverse engineer it and figure out how you made your product that you're selling, then I think you do want to patent that, because otherwise there's no other IP protection in what you're selling, because someone could reverse engineer it, which is totally legal. If you've got a recipe that results in something that can't be reverse engineered, or you think would take so long to reverse engineer that it's not going to justify the commercial effort, then perhaps you don't want to. Perhaps you want to keep that recipe a secret on the basis that you're going to get more commercial benefit by keeping it a secret, as opposed to applying to patent the recipe, which means you have to publish how it's done. And if someone infringes, you have to enforce. So can you patent a recipe? Sure. Should you? It depends, with, I would say, the primary criteria being, when you commercialize the recipe, can you still keep it a secret, or how long would it take someone to copy you should they want to?
We've got a question that's come in on a strategy front. How often do you see patents as the right strategy versus trade secret or another approach? I guess you've just given one criteria for evaluating whether to file for a patent or to keep as a trade secret, which is whether it's reverse engineerable. Yeah. Are there other criteria for that?
Yeah, there are a bunch. So I think in large part, it also depends on what stage of growth and development you're at. If you got to think, what are you using these IP rights for? And as you described earlier, perhaps it was Jen describing sort of the ecosystem in Canada, we tend to skew towards small and medium-sized enterprises, where a lot of these companies who are securing these IP rights are doing it not to enforce themselves, but rather to sort of crystallize the value in their IP so that when they go to raise a round of financing or they eventually do get acquired, those IP rights help to, boost their value. And a lot of times patents will do that better than trade secrets. Trade secrets are sort of amorphous. You can have leakage if there's a lot of movement in your industry. Company to company, employees are crossing the street, so to speak. It can be really hard to keep something a trade secret, even if it isn't reverse engineerable. Another consideration is if you practice something as a trade secret, then other people who are in the same industry may independently arrive at what you're practicing and patent it themselves. And that could leave you open to some liability. So another consideration is, do you want to apply to patent something so that it does get published and therefore prevents someone from patenting after you and sort of secures you that freedom to operate? So I think you've got a lot of factors. One, can it be reverse engineered, and if so, how long would it take, or how long would it take to for somebody to independently recreate it? Do you want to secure that freedom to operate by virtue of patenting? Also, how hard would it be to enforce? Even though you may not want to enforce yourself, ultimately that is where the value comes from in a patent, the fact that it can be enforced. So someone who might come to invest in you or acquire you, they'll ask themselves that question. If you've got a patent for a manufacturing method, for example, totally valid patent, but all the manufacturing in your industry is done in secret and nobody in the industry has any idea how anybody else manufactures, perhaps not a lot of value in that right. So I think it really does depend on the nature of the industry and the stage of growth of the company, the nature of the product.
Can I turn for a minute to ownership questions? In AI particularly, some people worry that that patent ownership could get messy, or figuring out who the proper inventor is could get messy, such as if you're relying on data, for example, for the training systems that you mentioned from other groups. Is that going to be a problem from a patent ownership or inventorship side?
No, generally, I don't think so. So one of the things we ask ourselves in patent law is, it almost sounds sort of flippant, but it's an important question. What is the invention? So if you are working on an AI invention, and you need a whole bunch of data in order to train your model and make it work. So let's build on the example I gave a few minutes ago, which is let's say a computer vision or some kind of AI model where you're picking items off a conveyor belt, and you need to train that AI model with a whole bunch of data of different objects that you may see on a conveyor belt. So in that situation, it's not so much the training data that is the invention. Most of this training data, well, I should say most, but a lot of it you can purchase, or someone can create it without having any idea of what your invention is, because the invention is the actual application of the trained model and not the training data itself. So the coders and the developers you have actually programming the AI model, who are tweaking it in response to seeing how it reacts when you're prototyping it. The people who come up with the idea saying, why don't we change this model in some way to make it better suited for our assembly line? Those are the people I would say I would consider for inventorship. The people who've created the data, they may have no idea what you're doing. All they know is they have to take a lot of pictures of different kinds of items that may show up on the conveyor belt. So I think training data is important. There are rights to training data you have to worry about, right? If you've just gone online and downloaded all these images of conveyor belt items, you might have a copyright issue. You might not have the right to use that data, but that is different from who's going to own the AI model. So I don't think AI or patent ownership is all that different from sort of a conventional analysis.
on that point, do you have any suggestions for people going out to get third-party data? What kinds of commercial terms should they be looking for, or what should they be worried about in those discussions?
I think ultimately there, I mean, you want to make sure you have the right to use the data in the way you're going to use it. I mean, a lot of commercial terms will put restrictions on how you're going to use it. They may say, for example, you can only use the data for internal business purposes. You might not be allowed to integrate it into a commercial product, which you wouldn't want if you were trying to commercialize your AI model. Another thing would be a lot of providers of proprietary data sets, I think understandably, want to keep the data set itself a secret. So they're going to require you to guarantee that if you take that data and integrate it into your model, that the data they license to you or made available to you can't be reverse engineered from your model. I think a lot of times, models transform this data using a lot of math. So that's generally not a problem, but it's something that, I think you should turn your minds to. And ultimately, there's also a lot of data sets out there that are available for research or that are free. So, if you can get some of those and use that for testing or proof of concept, that's a great way to start.
We've had a question come in that actually goes back to one of our earlier discussions about patentable subject matter, and wondering if there are differences between AI protection in Canada versus the US. And I know we've got some Americans on the call today as well.
Yeah, I'm just reading the question. Are there differences that companies should be aware of between AI protection in Canada versus the US? The test for subject matter between Canada and the US, the test is different. In fact, the test in Canada right now, the most recent test just came down about six months ago, and it's being appealed by our patent office. So who knows where exactly that will end up. Although I would say, generally speaking, at a high level, for the purposes of this call, I'd say the answer is the regimes are basically the same. Practically, I don't think there are differences between the Canadian and the US regimes that affect a lot of high-level strategy or decision-making. There is a difference in respect of the European regime, not in respect of the AI models, I would say per se, but data rights. So there is a database right in the EU where if you've got a bunch of training data, the fact that you've collected it and put it in a database, that database in and of itself is protectable under a European database, right? Which we don't have in Canada and the US. So there's actually a little more protection, I would say, for training data packages in Europe than in Canada and the US. But for the models themselves, yeah, I would say for the purpose of this discussion, no, not really.
So to be clear, AI is patentable, more or less, in Canada, in the US, to some extent. Europe.
I would go even beyond that. In the US, they have the USPTO has released a whole bunch of examples about what is patentable subject matter and what isn't. And one of the examples they've released that they've said is patentable subject matter actually goes to I believe it's an AI face detection method. So which I've actually relied on to get patents granted. So they're right. They're following their own advice. So I think that's right. I think yes, it's patentable, and I think at a high level, the differences don't impact the kind of conversation we're having today.
All right, I'm going to move on to another myth that we hear, and this goes back to our discussion about patents and trade secrets. Now, some people worry that if you decide to go down the patenting road, that means the whole thing needs to be exposed, and that means that you can't have any part of your process that's held as secret. How does that work?
So I think it goes back to sort of that question I posed earlier. What is the invention we're talking about, right? Let's go back to my conveyor belt example, which I did not know would be lasting the life of the Q&A. I might have picked a different example, but if we go back to the one I picked, and for manufacturing, let's say you start from items come in the door, they get pre-processed, they end up on the belt, they get picked, and then the picked items go and you manufacture something with them until you get a widget that leaves your factory. In that context, the quote invention, it's not the entire process, right? It's not processed from raw materials into your factory to widget out of your factory. If the innovation is the AI model that has been trained in a particular way to help with item picking on the belt, then if you wanted to patent that model, what you have to disclose is specific to that invention, right? It's specific to how we customize this AI model to do this item picking in a way that is better than everything that's come before it, what is called the prior art. So do you have to disclose everything about your manufacturing process? No. You have to provide what's called an enabling disclosure, a disclosure that is in enough detail that a computer programmer or data scientist or other kind of skilled person in the field can read your patent application and combine with the knowledge they already have about AI models, then go and recreate your improved part picking model. That's what you have to disclose. You don't have to disclose everything about your manufacturing process. And one of the interesting things I think about AI patent applications is that even though the training data for what are called supervised models is very important, you don't see in these applications people providing full copies of the training data. They'll reference the training data in another way. So they'll say, the kinds of data we used are a million different kinds of images where you had a widget with 5 sides or a conveyor belt part with 5 sides instead of 4 sides. And that's what we use to train the model. And here are a few examples. So you've got to describe, even in respect to the training data, what kind of data you use, or maybe you reference some kind of publicly available data set, but people don't append a million different images to their patent application. So even when you're talking about the actual AI innovation, there's not a requirement to provide, an appendix with training data that would make it really easy for someone just to copy exactly what you've done. You've got to describe how you've done it, but you can still keep secret certain aspects of the innovation. And certainly you can keep secret things that are separate from the invention, like in my example, the rest of your processing method or manufacturing method.
So this isn't exactly a myth, but we do hear frequently companies say that we're just not ready for patenting. We're interested, but we're not quite there yet. And especially in an AI context where iterations of training may go on for quite a while. What's the best point to come and talk to a patent attorney? When should you start down that process? How would you know?
So certainly before first publication or first commercial use or sale or offer to sell. I mentioned earlier, one of the requirements for patentability is what you've created has to be new. That includes new over everything you have told the world about. So if you go and you say you publish on archive.org this wonderful new AI model that you've created, that's great, except that could very well stop you from getting a patent for that great AI model. So you definitely want to, I think, talk to somebody to help you decide whether to patent before you've got that first publication or first commercial use, even if it's in secret, because in the United States, commercial use, even if it's secret commercial use, may be deemed to be novelty destroying. Another thing to think about is, if you're ready for patenting, the fundamental rule is you've got to have that enabling disclosure I talked about. So if you've done enough R&D that you can actually, or you know how to create your invention and how to make and use the invention. And maybe you've done in the AI context some simulations or some testing, and you've got your proof of concept, and you know it'll work. You know, you've convinced yourself that this is actually going to satisfy that utility requirement I talked about. It's going to do what we say it's going to do. That's your basic threshold for, can I file an application for this? Do I have an enabling disclosure? Is it going to work? And if so, it's ready for patenting should you decide to actually apply to patent it. We do have conversations where I think people, in fact, really are too early to patent something, right? Someone will come in and say, I know we could do this with this model. This is the idea. I know we can do it. We want to patent it. And then the next question is, well, how are you going to do it? Like what kind of training data are you going to use? What kind of model are you going to use? How well does it improve the functionality of the model relative to the old model? And because it's so early, people just don't know the answers. We don't know. We're confident it's going to work. And in that case, I would say, well, actually do a little more work on that before we go and apply to patent it, because it doesn't sound like you've got that enabling disclosure yet. So I think, the two biggest criteria are, one, do you have that enabling disclosure? Because that's what has to go in the application. And two, don't publicly disclose it or sell it or commercialize it yet. You want to talk about patenting before you do that. Otherwise, you might have found out you shot yourself in the foot.
Now, it sounds like one of the downsides of going in with maybe not a full enough disclosure is that you may have problems in prosecution later. Can you explain a bit about what prosecution is like for people who have not been through the patent process? If I come to you about getting a patent, does that mean I get a patent as soon as we're done talking? Can you tell?
No, it does not.
what the rest of the part involves?
So once you've got your patent application, you got to file it at whatever government office you decide to file it in. And in most places, the vast majority of places, before someone will grant you a patent, they give it to one of their patent examiners. The government office gives it to one of their patent examiners, and the patent examiners will check it for the criteria that we've talked about: novelty, inventiveness, subject matter in particular. And almost always the patent examiner will reject your application initially. Like at the US Patent Office, the USPTO, I think the stat is over 90% of applications get some kind of rejection, which is called an office action to start. And that office action or initial rejection, and then your response to it, and any subsequent rounds of examiner rejection and your response, that is prosecution. It's the back and forth you have with the examiner. So what'll happen is you file the application, and then depending on where you filed it, some time after filing, usually not faster than a year, unless you pay to speed things up, a patent examiner will pick it up, will look at it, will probably reject it, and then you have to go back and either amend the application because you think the examiner's rejections have some merit, or argue that the examiner is wrong, and in that way try to convince the examiner you're worthy of a patent. And that back and forth is prosecution. And that can take, you might just have one round, in which case it might just take a few months, or you might have several rounds and go to appeal because you just can't convince the examiner, but you're sure he or she is wrong, which can take a few years. There's a lot of flexibility there. If you're looking to defer costs with prosecution, one of the features of prosecution is that the timelines generally are kind of flexible, so you can slow things down and push the costs outwards, with the trade-off being you're going to delay when you actually get a patent. Contrary example is if you're in a rush to get a patent and you can bring some costs forward, in a lot of places you can pay to speed up examination so that you can get a patent quite quickly in under a year. So that's prosecution in a nutshell.
And that ties actually to a question that we've received from the audience about the average wait time from filing to a first decision by USPTO, Canada, and the EPO. And is there anything we can do to speed this up or or even check the estimated wait times for applicants?
So each of those offices has different answers. So the USPTO, the average wait time from filing to a first office action now, it depends on subject matter. I would say it's about a year. If it's a mechanical innovation, I find I get those a little sooner. If it's a software innovation like AI, it tends to be a year, maybe a little more than a year, but I would ballpark it at around a year right now. You can speed that up if you want. There are a couple ways to speed it up in the US. You can pay, just outright pay the USPTO to examine your application sooner. That's pretty expensive as these things go. You're looking at, I think, about $4,000, $2,000 or $4,000 US to speed up the examination process, but it speeds it up materially. If you pay that money, instead of waiting a year or a year plus to get a first office action, you'll get it, in under 6 months. And then when you respond to the action, the examiners will pick up your response much more quickly. So if you pay for that kind of advanced examination, I've done it a few times, several times the last couple of years, and I end up, in those cases with patents in under a year. So you can pay to speed it up. You can't expressly pay to slow it down in the US, although there are extensions of time you can take, and you can slow things down that way just by sort of slow playing prosecution. In Canada, again, it's a similar system. You can pay to advance examination by paying a fee. It's a lot less money than the USPTO fee. The government fee in Canada is $500 or $600. So you can pay to speed it up, and you can, in fact, intentionally slow things down in Canada, because after you file an application in Canada, you have to actually expressly request examination on it. Examination doesn't occur automatically like it does in the US, and you've got up to 4 years to request examination. So, if you're looking to defer prosecution costs and you just want to file your application in Canada to reserve your rights, you can do that and then not actually request examination for quite some time. The current queue in the Canadian system, I'd say also is about a year between filing that request for examination and getting that office action. I expect that to go up in the next year or two, because there was just a rule change which resulted in a whole bunch of requests for examinations being filed. So I think that year wait is going to get longer in the next year or two. I just don't know how long yet. And in the EPO in Europe, the first report is pretty quick. I'd say under a year from when you file. Where the EPO slows down is subsequent reports. So when you file a response, it can take the European Patent Office a long time to get to your response, pick it up and read it and respond to you. I've had to wait after a response like up to a year to get a second response, which is way slower than Canada or the US, where I would wait, 3 or 6 months. But like in the US and Canada, in Europe, you can request advanced examination as well. So if you're in a rush, you can make that request and they will speed things up. Oh, sorry,
Now,
the last part of the question, how can the estimated wait times be checked by the applicants?
Yeah.
I don't think there is a way in Canada, and to my knowledge, Europe. You just have to sort of do it statistically. In the US, there is a little automated tool, which the USPTO website gives for each case time to first office action, which will give you an estimate. It's in the ballpark of how long you'll have to wait, but I've never found it to be a ton of value. I think in all these jurisdictions, really you're just looking at it statistically and then waiting.
Now, meanwhile, while you're waiting to find out how your prosecution goes, are there advantages to just being able to say that you've got patent pending?
Sure, yeah. I think in terms of legal advantages, not a ton, right? Until you get a patent grant, you don't have an enforceable patent right. But patent pending in terms of marketing, in terms of investors, in terms of growing your company and telling the world you've got an innovative technology, I think yes.
Do you think there's also some deterrent effect if people see that your technology is patent pending?
Yeah.
They may be less likely to outright copy you?
I think people think twice about it. Yeah. The application, your application after you file it, as a general rule, will publish a year and a half from when you first filed it. So if you say patent pending and it hasn't published yet, people can't look it up, and they're really not going to have a great idea what the scope of your claims are, the scope of your application is. So that could definitely give them pause. And after your application publishes, people can look it up, and they may say, well, this is what they're going for. We don't know if they're going to get that scope of protection at the end of the day. We're not going to know for a while, and we have to adjust our strategy accordingly, because there's a risk that they may get this broad protection, and that's going to impact what we want to do, and we have to take that into account. So, at the end of the day, like I said, you don't get an enforceable legal right until your patent grants, but there could be other practical benefits to advertising patent pending.
Now, I see that that we're running a little low on time, and I do want to leave some time at the end to tackle some of the additional questions that have come in. But first, I wanted to pick your brain on something that's been in the news a lot lately about whether an AI itself can be an inventor. And I know that this British system, DABUS, there had been an attempt to file a patent application in the name of DABUS, and you had done some reading into this and have spoken a couple of times about DABUS. Now, can we have your thoughts about robot inventors of the future?
Yeah, I think I don't think it's a good argument. I don't think AI should be inventors. Look, these AI models, they are just different ways of programming computers, right? It's all math when you get to the heart of it. It's a lot of math. It's very complex math. They can make computers do things we're not used to having them do, so it's quite impressive. But they're just differently programmed computers. They're productivity tools, just like the productivity tools we're used to, but aren't amazed by anymore. So we tend not to think, I should name, my simulation software an inventor because it's been around for 20 years and I know how it works and it does what I expect it to do and I don't find it impressive. But because these AIs can do things I'm not used to and do things that traditionally only the human brain have been really good at, I think intuitively we want to give these AIs a sense of agency, which they do not have. I think we're also primed by Hollywood to think AIs are a lot more advanced than they are. I mean, if you're roughly my age and someone says, what's the first thing that comes to mind when you think AI? I think Terminator. I just can't. I always think walking, talking robot, which is not the case, right? I mean, a better example of AIs I use every day are, I don't know, like my iPhone autofocus, which tries to find the face in the picture and which guesses wrong maybe 10% of the time when I curse how dumb my AI iPhone is. So I don't think, I think it's an interesting topic. I think every once in a while these topics sort of get into the media and capture the public's attention. But do I find it a particularly compelling argument that AI should be named inventors? I do not.
Good to know. I'm going to shift to some questions then. First one that had come in a bit earlier, what can Canadian provinces do to help support this industry to grow and protect this unique knowledge or intellectual capital?
I don't have a great answer to that, frankly. I mean, I think they've done a lot to date in terms of things like supporting small business and tax credits. Shred is a great credit. We have a lot of government grants in the country. The biggest thing that I would say comes to mind is purchasing from Canadian companies. I mean, that is something, talking to clients, that I hear a lot about. And very frustratingly, it's just been in the news again recently, right, with the ArriveCan app and $50 million to make an app of, and some of that money, according to articles I've read, didn't even stay in the country. I think purchasing from Canadian companies would be the first thing that comes to mind. And I think, they've done a lot of other things to help. But I'm not sure if on the supercluster side, you've got better policy ideas, or not. That's fine. Hey,
Come back on screen again. Maybe I'll turn that one to Jen. What do you think?
Jumping in here. Yeah, I mean, I think definitely as a a program, sort of the superclusters are very much sort of focused on the Canadian, the retention and the creation sort of Canadian IP, and very much sort of baked into everything that we do sort of within our programs, within our projects, within sort of the multi-party agreements that selected projects sort of go into, and really trying to bolster and boost out sort of the ecosystem. So I think as we look now to the conclusion of phase one, and sort of a lot that's come out of it, and as we approach sort of the second phase, more and more emphasis sort of on that, and how we can continue to sort of to bolster and champion the sort of the made in Canada but for the world approach.
Amen. Another question related to if there were specific tips or guidance around considerations for data sharing agreements and things to think about for AI data sharing.
I think you think about, it's going to depend on the context, right? Like, is it in the context of purchasing data from some kind of repository or provider? Is it your own data that you're sharing with partners? Are those partners potential competitors? And, what's the nature of the data? A lot, I've got clients where the data is health data, right? It may be from a wearable, in which case it's even more sensitive than regular confidential information. And there may be different statutes and laws that apply to protecting that health data and that personal information. So, generally speaking, you're looking at, a lot of the considerations that go into all kinds of confidential information. What is the information that you're sharing? What are the restrictions on use you're going to place on it? Are they only allowed to use it in the model, or can they use it in other ways? And, can the data be accessed through the model, through reverse engineering in some way? Who's going to be allowed to have access to it? I think best practice is on a need-to-know basis. Just because you've given somebody data and they've signed a confidentiality agreement doesn't mean they can sort of do a email to entire company and say, here's the data, it's confidential. You want to maintain access controls on that. And then, generally speaking, these agreements also say that when they're done using the data, they have to destroy it or return it to you, subject to either, some kind of backup they may be automatically creating on their systems or what have you. So it's basically controlling use and access to the data, with, I would say, an overlay being, if the data is particularly sensitive, like health data, there are a whole bunch of other requirements that might come into play.
Okay, switching gears, I'm going to read this question. If some AI model recreates images based on databases, are these AI models in risk of being in legal issue if some of the output images are IP protected? For instance, creating a new Picasso with AI, does that make the AI model creators liable?
So I think this question goes to a lot of these new art creation AIs like DALL-E, where you could basically type into the prompt, I want a picture of, I don't know, a coffee cup on a table, and it'll spit out 100 different images of coffee cups on tables based on all the data scraping it's done and based on what it understands to be coffee cups and tables. Sort of a sidebar, I just saw a funny example of this yesterday. Someone typed into one of these prompts, salmon swimming upstream to spawn. And the output was the stream and the rapids and a fillet of salmon jumping out of the water, because the AI thought salmon, of course, was just the fillet you see in the supermarket as opposed to the actual fish. Anyway, not related to the question, but I kind of chuckled at that. Yeah, I think the answer is potentially. I don't have a great answer to this question. I had been thinking about it sort of in the back of my mind. But I think there are two different ways that there could be an issue here. One would be, this goes to the way the question is worded. The question is worded, what if some of the output images are IP protected? I mean, in that case, if the AI hasn't actually transformed anything, if the AI has scraped something from the internet, which is copyright protected, and it, for whatever reason, has output an image with that same copyright protected image, then I think there could be a problem. It's a straight up example of copyright violation. If it hasn't done that, if it's scraped all these images and then done some kind of transformation on them, then the question is going to be, well, is it still a derivative work of what came in, right? Was it some kind of substantial copying, or was the output somehow based on the input that it's there should be liability because they're too closely tied, or there wasn't a sufficient transformation, or what have you? And my best answer to that is potentially, and I don't think anybody has an answer to that right now. Like, I don't think there's any litigation on point. I think it's still pretty academic, and I think really my best answer to that is to be determined.
And probably if you're building a system, don't build it dependent on scraping images from other people.
Yeah.
How's that, right?
I mean, the thing to remember about that is a lot of times that will, there are companies that have done that and that are very famous for doing that, but they're very big companies that can deal with the legal fallout. Where I think they know full well from the beginning what they're doing is going to get them into trouble, but they want to do it, and they know that they can pay the settlement or come to some kind of deal or afford to litigate it. And without naming names, that's not uncommon if you're a company of certain size and resources, but that's not going to work, I think, for your typical 10-person company.
Well, Mr. Ripley, we've sure put you through your paces today. I think you thought you were going to come here and get a really softball, sort of Pat 101-ish kind of talk, and we gave you lots of complicated issues and some really up in the air sort of issues to chew on. But thank you for your thoughts and your good sportsmanship today, and thank you for finding these Fern diagrams for us. That's super fun.
My pleasure. Thank you for thanks for the invitation. I thought the questions were great. I think one of the cool things about this area is that it's still developing. So yeah, I don't have an answer to some of these questions. At the same time, I'm not sure anybody does, frankly. Like the AI artwork question in particular is very prominent right now. So no, thanks for the invitation. I'm happy to answer any questions that people may want to send subsequently via email. And maybe we can do it again one day.
That sounds great. Well, I see that we're just about at the hour here, and I want to thank our co-host, Digital Supercluster, Jen Milguy, and thank you, Roch, again, and thank you, audience, for fantastic questions and for your attention today. Look forward to some of you joining us as members, hopefully down the road, and wish you the best with your AI project, wherever that takes you. Happy Tuesday, everybody. Take care.
Thanks, everyone. Bye.